Hi, thank you, everyone. So I think it's important for us to set the stage a little bit about what privacy and security has looked like over the years. And so as you can see here, particularly privacy has had quite a long history, dating back to really the early 1900s when the FTC was first established. And then you can see sort of a timeline here up to present day. And there's really probably not enough room on this slide to even talk about all of the other data privacy laws, some of which are not here on this slide, but important. So the new Chinese data protection law, Canada has a more recent data privacy law on the books, Brazil as well. And so this is really an evolving landscape, especially here in the United States, as you can see here coming up with in 2020 in California sort of revising their data privacy law. I think it's also important as we talk here to understand that data breach laws have been on the books much longer probably than most data privacy laws in terms of state laws. So something to keep in mind as we continue talking.
Yeah, so from a cybersecurity perspective or security perspective, when we think about, again, setting the stage between this partnership between what's privacy, what's security, what do we do? I think quick backstory before I get into the federal, the regulatory side of this. Karen and I both come from healthcare, so we're speaking at this from a healthcare very specific sense. And I think healthcare in particular is one of those industries that has had a robust privacy law, obviously with HIPAA, for a number of years, and other industries don't necessarily see it that way, where the programs that are getting stood up, sometimes they tend to be conjoined, between security organizations or through legal departments and things along those lines. Whereas in healthcare, it's very common, in fact, it's required under law that you have a designated privacy officer, you have a designated security officer, and so forth. So some of the contours of how privacy is set up and how security is set up is obviously stems from the regulatory side of the house. On the security angle within healthcare, prior to HIPAA, there really wasn't much. There's the one law that everybody always goes to, which is the Computer Fraud and Abuse Act back in the 80s. And that's, you can't hack people, and if you do, you can be, prosecuted for that. Fast forward to 96, and in the healthcare space, you get HIPAA that launches, which was really focused in 96 about portability of information for getting insurance coverage. And then, 2003, 2005 is when the privacy rule and security rule itself, those enacted. And in the healthcare space, 2005 was a very big moment for security and having to have obligations to do things. So things like risk analyses were required, a few mandatory items that were in there, but it was a very flexible regulatory framework, where it's not prescriptive like PCI is prescriptive, where you must do 300 things if you ever store card data, cardholder data or something along those lines. Fast forward from between 2005 and 2022, though there are some laws that were put on the books, most of it was very specific to very specific things. So like the Homeland Security Act had some FISMA stuff that had to do with specific federal regulations and federal items. 2015, we saw the first overarching cybersecurity, the Cybersecurity Act of 2015. We saw some notification items that provided safe harbor for reporting to CISA within Department of Homeland Security and some other things, but these were not mandated items. These were more assistance-based items. There were some provisions in there that called for partnership within critical infrastructure and the federal government and industry to come together. Part of the other job that I do is, on a pro bono basis, is I chair a cyber working group within the health sector and work with Health and Human Services, and part of that is actually stemmed from that law, from that 2015 law. So, but after that, not much, in the cyberspace specifically. When we think about breaches and such, that's really privacy. It's about people's private information, the rights that those folks have, and the roles that cyber played in that. Now, we've got stuff coming. In 2022, the Strengthen American Cybersecurity Act, which had a provision inside of there, which required mandatory reporting. This is the Cyber Incident Reporting Act for critical infrastructure. For the 16 critical infrastructure, there's rulemaking that's starting now, where CISA is out there sort of doing some background information. It's going to take them about 5 years, though, before they're going to actually do a proposed rule on this. But there's going to be some mandatory reporting to CISA in the case of specific cyber acts. And then there is a lot in the pipeline. There's FTC is looking at some stuff from a privacy angle around surveillance and consumerization of data. Senator Warner's office is looking at a comprehensive overhaul on healthcare cybersecurity. There's medical device security acts that are out there. HHS and the NSC, the National Security Council, are looking at minimum standards for critical infrastructure. So there's a lot of movement happening in DC right now on what should we be doing, in this space. Just hasn't happened yet. So expect more to come in that mindset.
Yeah, and I think it's important to note that we'll probably see more cyber coming down the front before we'll see a lot more private data privacy. So what we're seeing here is really what is the distinction between what is privacy and what is security. So privacy is really about people's rights. What is the rights that they have to the data that they're giving us in any of the areas? And so how are we acquiring it? How are folks accessing it? How are we using it? How are we giving that data away to other people? And how, in terms of use, how are we using it for our own internal functions? And then how are we using it externally? So did you want to talk about security?
Yeah, so, and of course, those CISOs in the audience are probably thinking, well, I own access management. We're constantly putting out role-based access or trying to figure out what's appropriate, what's not appropriate. So is that my job or is that privacy's job? So this is where it's that combined effort, where you have organizations that have privacy officers. This is where you leverage one another. So the privacy officer in my career has always been my favorite person, in my favorite partner, my favorite friend, because we work on who needs to have access to this information, and then security comes in and defines how we actually achieve those ends. So privacy can help define the contours of that. What do the policies look like? How does this sort of represent itself? And we're kind of the how. Now, cyber goes beyond just data protection, though, and I think this is something that has evolved in our field over the last 10 plus years. As the threat space has come in and started causing disruptions in the actual business operations, in healthcare, when we talk about going digital, now we have massive volumes of patients coming into our environments. We have digital portals. We have all these things, all these systems that are used in the provisioning of care. And if those systems are not up and operational because of some kind of disruption, could be ransomware, could be DOS, could be IT outage, could be any number of different things, that impacts our ability to actually care for our patients because the volumes can't keep up anymore. We built these systems to do that. So we have to decompress and we have to go into business continuity plans, downtime procedures, and so forth. So there's another angle to cyber, which is about hygiene. It's about resiliency. We heard that earlier today at the keynote with Kevin Mandia talking about that. However, so when I look at cyber, I think of protection of confidentiality and privacy. I think about organizational resilience, and I think about the protecting of our financial assets, and fraud against our assets and sort of how we stop that. When we get into this shared space of protecting of the private information, you can see here below, there is a lot that we do in both programs that are actually connected to one another. You want to talk about a few of those?
Yeah, so things like how we run incident review. We're going to talk a little bit about what it looks like to actually run jointly an incident and how to leverage each team. how we manage enterprise risk management at the board level, so ways that you can link with your privacy officer, security and privacy can link together to provide a unified message that you're both carrying forward. Certainly the idea of data classification or just understanding the flow of data within your entity is very important. From a privacy perspective, obviously, because we always want to know in privacy, what is the purpose behind what we're doing? That's really the main driver for the decisions that are made in terms of privacy, or what the regulations are, what is the purpose of those regulations and how it's being used or accessed. And security can then help, once we understand that, to actually provide the technical controls to make sure that the purposes are being fulfilled.
Yeah, I'll give you an example. So as organizations are moving forward fast, in the digital space, you might come up with you might have sensitive information in your hands. You might have an IT project that's undertaking a new use of that information. And some of your security folks might go, is this okay? Can we take this information which was intended for purpose X and use it for purpose Y? It's a great question. And it's a great point where the security folks can kind of use that hit the tap the brakes kind of moment, come over to our privacy friends and say, what do you think about this? Is this sitting within the contours of our contracts, of the obligations, of our regulations? Are we on track? Are we off track? How do we partner around, what this looks like? And then our privacy folks might have questions for us, like, well, how's the data going to be segmented? What's it look like? What's the access permissions? Who's going to have access to it? Can you help us out, sort of understand the contours of what this new use is going to be? And that's an absolute perfect harmony of relationship when you can have that with both of your offices.
So this wheel here really defines all of the areas, not inclusively, but all of the main areas where privacy and security can find partnerships, strategic partnerships, really. And so just to call out a few here, and then we'll talk a little bit more in depth about some of these others as we continue the talk. But this morning we heard in the keynote some talk about how information and cyber and risk is actually translated down to the business and the board. So really getting people to understand what those risks are, or training and educating people. And I think this is one key area where privacy can absolutely partner with security, because it's important for the security team to be able to share with the privacy team exactly what is happening in a way that privacy can understand. We do not technically come from that type of background. And so it's a good experience for the security team to be able to explain it in a way that is understood by privacy. And privacy can then also carry that message forward in the similar way that security is doing that. Other opportunities, I talked about data maintenance, retention and destruction a tiny bit in the last slide. But again, this is another area where, defining the types of data that you have, how are you retaining it, how are you maintaining it securely in order to keep it from being breached, for example. This whole idea of merger and acquisition and due diligence, and there are situations that I've been involved in where the security officer and the privacy officer are both sitting at the table and really having a discussion with senior leaders about what does this merger look like, what does this acquisition look like, and then fielding questions from both security and privacy playing off of each other when the answers are being given.
So we'll cover a couple of other thoughts here. So when you think about board engagement and the way you speak to boards, one element of that can be useful is using enterprise risk management frameworks. And so if your organization has gone through that ERM methodology, you got to be careful, especially if you're gonna separate privacy from cybersecurity in the context of ERM. So think about it in the sense of you could have multiple pillars. You could have a cyber risk pillar. You could have a financial risk pillar, an operations pillar, privacy pillar, and so forth. And so as you're doing that, and you want to highlight the risks, right? So from a cyber perspective, I always like to call out the 3 risks that I just talked about. In healthcare, it's patient safety and sort of how cybersecurity falls into patient safety, security of our financial assets, confidentiality of our patients and members if you're in a health plan, and then growth and expansion. So the merger and acquisition sort of item. So as you grow and you add more complexity inside your environment, you're bringing in all this new technology that it has its own inherent risk because you have to standardize that and move that forward. Well, of those 4 that I just described, one of them, confidentiality of our and protection of our confidential information, is really related to privacy. And so in working in communicating to the board, you need to make sure that you're in lockstep with your privacy officer or your compliance officer, whoever is going to be there, and sharing the same message. Or maybe if you think about privacy and security as 2 sides of the same coin, there are certain elements that you might want to talk about from a security angle, whereas the privacy officer might want to come in and talk about it from maybe an access, use, and disclosure angle, about how that's all being used. And then we support one another in sort of that message. And another example of that could be, the security incidents that happen inside the organization. Certainly the CISO is going to report on those kinds of issues, but the privacy breaches themselves that might spin off from a security incident would be reported out through the privacy officer. Just another use case of how these 2 things can connect. And so obviously, if you ever get questions about from your board about how this is all working, you need to make sure that you are in lockstep with one another, supporting one another, and you have a good message to send. So we're going to dig into the use of one specific use case. We have a couple more here as well, which is really about how to leverage some of the resources and tools that are in place within cybersecurity organizations and how that can help the privacy office and the privacy programs. Data loss prevention is a very key thing that us cyber folks know a lot about. We got DLP tools. They trigger on information flowing across boundaries that we don't want them to necessarily flow across, and we usually have to do something about that. You've got risk management tools. You've got data in your SIM. You've got all these other kinds of things, risk rankings and all these other facts and circumstances that we can produce from a technical angle on the cybersecurity side. Now, one thing that I've done in several organizations now is just using the DLP as a use case. So when you have DLP alerts, you have DLP system, so cybersecurity teams put that in. You have alerts that come out of those. Your SOC might take those alerts and start doing some triage, doing some background investigations, figure out the facts and circumstances and the context around that. And then, you have this kind of moment of, well, what do you do about what you just picked up? And that's the place where, in healthcare at least, it's very common, to turn over to our privacy folks who also have an incident response team and also have privacy incidents that they're taking in, and we work together to figure out what happened here. And then usually the privacy teams will, at that point, sort of take it on, unless, Karen, you disagree.
No, I don't. But I think the interesting thing about the DLP is that oftentimes you don't think privacy, while not so technical, actually can have reports run automatically for the privacy team based on specific parameters, or, depending on who your privacy team is, could actually be taught to review the DLP logs.
What about the EMR auditing? That's another good example.
Yeah, so in healthcare, we have to take a look at who's accessing what patient records for what reasons. And so we have a monitoring tool that we use, very similar, that will actually, flag what appears to be potential impermissible access. And so the privacy team is already trained in how to take a look at those logs and try to, make sense of what people are doing. So really going back to what I was just saying about this idea of purpose. What is the purpose? And trying to put context around.
Okay. So another use case that we'll talk through is, we get into joint incident response. So, this is one of those cases where, as we showed a few slides ago, we both have incident response teams as an example. We both have these in our program, so certainly within healthcare. So let's just sort of walk through this, as like a process perspective, sort of how it interchanges. And we'll use, ransomware as a good use case of this because it's certainly of top of mind. So you could have something come into the organization that starts off as a security incident. Say like we have a ransomware intrusion, or you've got some other kind of intrusion that hit, and your SOC has picked this thing up. Your analysts are looking at it. We've done our severity ratings. We classify this thing as potential big, high-risk issue, and has the potential to get access to sensitive information. So that's step one in this process. You've got the analysts have done their job. They've done their triage. They've done their severity ratings, and you have the potential for this to become large. So in a large-scale response, very common, I'm sure many people have this in their organizations, where you have a CERT. We call it the PCERT, the Privacy and Cybersecurity Emergency Response Team. It's a very small designated team. It's made up of the CISO, the privacy officer, legal, usually those three. Sometimes you might add a few other folks into it, like communications and so forth, and or maybe your compliance officer, depending on how your organization is. And you might activate that CERT, and either the privacy officer or the CISO can make that call, to say we're activating. We have to bring people together, and we have to make a response, based on what potentially could happen. In the case of ransomware, the CISO has, we've got two things that we have to worry about. We've got the data itself, and was their data accessed in an impermissible way, and what are the facts and circumstances around that access, and the forensic data and proof of that or lack thereof. And we have an operational impact. You're kind of at a decision tree moment. Do we have an operational impact or not? If you have an operational impact, you're moving off into a different arm at that point. Privacy is right there. They're hearing all the what's going on. They're understanding that there's an attack. They're in the briefing. They're in the meetings. They're advising from the perspective of protecting the sensitivity of that information. But off on the operational impact arm, we might be instantiating emergency management or emergency operations. So in healthcare, this is it's called incident command or hospital incident command, based on which version you use. And that is, think about it as like your regional incident commands, like FEMA for hospitals. You activate an incident command structure. There's an incident commander. There's different pillars underneath that. There's logistics, there's supply chain, there's finance, there's SMEs. And we are trying to contain the damage to the operational arm of what's occurring. You might go on downtime procedures. We might have to proactively bring systems down. And we're going through trying to evict a bad actor out of the environment and sort of bring things back up. When you close all of that, or rather in tandem with that, although it can be a lot to try to handle a privacy analysis while you're also in the middle of bringing a system up and out of operations, you kind of move over into this right space.
Yeah, I was just going to say, I think this is where the parallel has to run at the same time. And so this is really the benefit of having privacy at the table from the very beginning, because as the security team is actually running this, bringing operations back, trying to figure out everything that's happened, trying to help the privacy team understand if there's a data impact, the sooner the privacy team can know whether there's a data impact, the more we can inform based on, if you think back to that very first slide and the history of all those regulations and laws, can help provide context for what that looks like. So either I would say to Erik, you need to really hurry up and give me the information I need, because we need to really start doing a risk of compromise assessment, or it's okay, we have a little bit more time for you to really dig in and get back to me.
Clock is ticking.
Exactly.
Right.
So I think, that's what happens. And so we can, usually a seasoned privacy officer can tell fairly quickly whether we're going to have a privacy incident. And if you'll recall back to the other slide about all of the systems that you can leverage to bring privacy into, that also helps us to understand what is the impact, what is this actually looking like from very early on. And so again, all of this informs the risk of compromise assessment that we would perform and try to understand what regulations or whether we have a breach situation. Now, that being said, while privacy is the one, sort of informing, we would not do that without discussion with the security officer and legal. I mean, this is to Erik's point, everyone sort of has a seat at the table for varying purposes, but we're constantly in motion talking. And then, of course, step 4 is where we're looking at, do we actually have some obligation because there's a breach and we have to start notifying people, and what does that look like? And then always some sort of after-action review in tandem between the two teams.
I think there's 2 other things I'd add to this. One, for those of us in healthcare, we use the term breach very specifically. Sometimes we call it big B breach. And what that means is there's a regulatory breach. And I know as a term of art within cybersecurity, we use there's an intrusion in our environment, it's a breach. And so if you're in healthcare and you see people walking around saying we got breached, you'll immediately hear people starting to say, stop saying that. There's an incident. It's not a breach until we've done our risk of compromise assessment, until our privacy folks and legal folks have done that with the context of everything that's happened. And also to note is, Karen mentioned that there's the clock starts ticking, based on when that there is protected information. In healthcare, it's PHI. And, so you have regulatory clocks, or you have federal clocks, or you've got state clocks, depending on, what information you're dealing with. This is going to be interesting to see how things move going forward. Now, that's specific to enumerating all the individuals that have been impacted by this, and that takes time. I mean, it really does. Even if you have the data set in front of you day one, when what has happened, it takes time to actually parse through that data set to understand the context of what the access was, who was where, are these people even still around, did they move? All data is static at one point in time, and then when it relates to people's personal information and getting to them it takes a moment. So as we see new laws coming out, new breach reporting laws that are going to come out, GDPR kind of did this. I mean, with GDPR, it was within 72 hours you have to notify the appropriate regulator that there was an incident. Now, that doesn't mean you have to notify all the impacted parties of all the individual people that were breached, but you have to notify that there was something that had happened. We're starting to see more of that coming in with cybersecurity. So as I mentioned earlier, the American, we call it CIRCIA, the Cybersecurity Incident Risk. I can't remember the whole thing. I'm sorry. It's on the slide. That law is going to say, it does say, for critical infrastructure, if you have a significant incident within 72 hours, you have to report that to CISA, the Cybersecurity and Infrastructure Security Agency. Well, what is it that we're going to report? These are all this part of the rulemaking that's going on right now as far as what's inside of all of that. The intention is to get to IOCs and TTPs because within 24 hours after you report, CISA is required to share that within the federal government, and then they're supposed to do something about it. So the whole intention of this law is if somebody gets hit, protect everybody else. But there is going to be a clock that's going to hit, and there is potentially going to be privacy implications associated to that, or you're going to have to make distinctions in your response plans on how you're going to account for that reporting arm versus the OCR reporting arm versus a state's attorney arm, those kinds of things. It gets complicated when you're in a highly regulated space.
And just to emphasize, this is not just about state law or federal, this is international law, which is why it is so important to understand. Early on, I talked about privacy and data flow and data mapping. I'm a huge proponent of privacy and security by design, and I think that is one of the very early benefits to adopting that mindset, because that's really going to tell you what you have where.
Okay, another example.
Okay, yeah. Okay, so this is another, this is probably one of my favorite examples actually, is when you are contracting with somebody else, this is one of the purposes that privacy is interested in, because we want to know, is there a legitimate purpose for the contract and the contractor potentially being able to get access to the data that you hold. And so there are lots of times when I might be in a meeting and I might hear something and somebody in the business wants to propose to do something and they're going to hire this consultant or this other vendor to help, but the security leader is not in that same meeting, or even vice versa. So security is in an IT meeting and they're hearing about something. And so one of the best ways that the two teams can jointly form a strategy is through this idea of contracting. And so making sure that there is both a privacy review and a security review at all times. And being able to say in a meeting, hey, have you run that past the security team, or have you talked to privacy about that? Because you have already been talking all along, and so you already have this relationship and at least more than basic knowledge of what the other is working toward, and again, working toward the same goals. And so in terms of privacy, we want to obviously look at this whole idea of purpose. What are the minimum thresholds for disclosing or acquiring data that we believe is acceptable? And this is really just about organizational risk tolerance, a lot of it. And then privacy impact assessments, while sometimes required under the law, are almost always a good idea, even if they're not required, because you need to go back to this understanding the data that you hold. What happens if something goes wrong? How are you complying? What are the risks associated with it? And for me, I always like to understand from the security officer, what does this look like? What is this security posture of this other organization that we are contracting with? So for example, if the liability on that contract is $1 million, but Erik tells me, their security posture is terrible, then probably not going to want to accept $1 million in liability. So those are ways that the privacy program can really get involved in what does that look like. And so one other piece to this that's really important is this idea of sort of secondary data use, which is how, when you engage with somebody else in a contract, how that other entity might want to also use your data for their own purposes, whether it's in a de-identified form or an anonymized form or whatever. It's really important to understand that as well. And so this really goes back to just the initial contracting.
I think we'll cover kind of, I think, that secondary data use thing here in a second as well. I would just go ahead and just re-emphasize, what Karen said here. I mean, there's processes that we have in place, hopefully. So be it if your contracts are coming through your purchasing offices, your supply chain, whatever you call that in your organization, or your legal, that you have this as an actual robust process that has an entry, and then in that process, you're forking this out to both security to do the third-party risk assessment, so we can understand the contours of the vendor themselves and understand, we care about the data that they have access to. We care about the data if it goes into their environment. We also care if they have access to our systems or they're a conduit into our environment. They might not have any data at all. They might not be serving in anything other than a services type of organization, but have a conduit in. And that conduit can lead to a data breach, because we are seeing, as again earlier this morning in the keynote, how these third parties are ways in, into our world now. And so, and then just coming back to the point of when you're actually negotiating down to the language itself, within healthcare, you've got business associate agreements. If there has access to PHI, it's very specific within, and that's actually regulated, that there must be a business associate agreement for vendors. There's no regulation that says there has to be security terms, which is interesting. But we still throw in terms. We build our own amendments and things, and it's kind of commercially accepted that this be the way of things. So, when you find these risks and you find these issues, my advice is put it into the contract. Like if there's a high risk issue and we're going to continue moving forward this and we're not going to take $1 million liability, it's going to be $10 million, and it's because you don't have two-factor authentication in your systems, say, you're going to put two-factor authentication in within 12 months, from contact effective date, something along those lines. And these are just ways that, again, we support one another, and usually, hopefully, you can have a process where it's going through every lane, every party for final sign-off before it goes forward. So where's the future of this going? What are some of the things that we're seeing? I'll cover one of them, which is on the secondary use or just ethical use of data. From a regulatory perspective, we can de-identify information, we can anonymize information. In some cases where you're in an unregulated industry and it's consumer data, you're allowed to use that information in any number of different ways. But there's kind of an ethical sort of responsibility on this, and I think our public is getting more sophisticated with this and is going to demand, sort of more expectation. The FTC is starting into this. There is a rulemaking exercise that they're going through, which is around surveillance. What was it called? FTC?
The FTC.
Yeah.
Data surveillance.
Data surveillance. Yeah. Okay. So they're looking at or companies that are aggregating huge, massive data sets and saying, is this appropriate? Should we? What are the consumer rights? In here and using whatever their own authorities are to sort of see if that's going to change the tide at all. And I think that's important. I mean, when you think about, it might be legally acceptable to share and move information and share data around, but I always got to think about, like, is this the right thing to do for our consumers, for our patients and members?
Yeah, so going on to the next one, as a service model and outsourcing, I mean, really to think about from a privacy officer's perspective, when you are outsourcing IT services, things like that, how would the privacy program then partner with that outsourced team? So what does that look like? Because it's very different when you're used to, going to lunch with your security officer at least once a week, and then all of a sudden IT services or even security services are outsourced. And so just to think about what does that look like in the process that Erik and I have just described, and how will you account for that? Wanted to also just go back to the idea of this corporate social responsibility. I mean, one thing to also consider there is that AI and those types of technologies are really coming forward and emerging, and taking a look at what does that look like for your organization if you're starting or have in place things that have artificial intelligence. And are there biases involved in that? That's been coming around quite a bit lately, and it's definitely something to start to think about in terms of social responsibility. Moving forward, the regulatory issue, I mean, we talked a lot about that in the first slide. This is a rapidly evolving, rapidly changing environment. And so you're going to, I think, see, as I said before, a lot more security rulemaking and legislation, probably before you see, at least in the United States, more data privacy, or you'll probably see a lot more data privacy at the state level. So something to look out there. I mean, there are 120 countries right now that have data privacy laws on the books. And so this is another reason why it's really important for security teams to engage with their privacy officers, because the security teams can't be expected, and privacy officers themselves can't be expected to learn 120 plus odd data privacy laws. But we certainly would know what laws would impact our business specifically, because that's part of the privacy role, as I've talked about, understanding the types of data that you hold and what is the purpose, and then what is the regulation behind that that you need to follow too. And then lastly, just wanted to mention about this idea of team challenges. I don't know that it's a challenge, but more of an opportunity. I think that one thing that's important is this idea of stepping into each other's space. And so I think it's really important to forge a relationship with the two teams together, so that you, I don't know that I'd call it a friendship, but a really good working relationship, so that neither feel like you're stepping into the other's space, but that you both feel like you can give an opinion about something. And I think that, one of the things when Erik and I worked together previously, we spent countless hours, really just educating the other about what does it mean to be in privacy, what does it mean to be in security, and so that really, I think, has made all the difference.
So that is our talk. Any questions? We have a few moments. Yes, sir. So I think we're going to have a microphone come up.
Great. So both of you come from institutions that not only deliver care but do research.
Yeah.
So I'm curious about the collaborations that are carrying forward into the research space, where potentially it's really about secondary use or a different type of consent, or you've got human subject research obligations and those sorts of things. And how do those collaborations happen?
You want to start?
Do you want me to start?
Yeah.
Okay.
Have we done this before? Yes.
Okay. I mean, I hate to sound like a broken record, but obviously the first step is to determine the purpose, right? And so in this case, it's research. And so you have to go back to the regulation at this point. And so it really is dependent upon how the research institution is set up. And that's more of a regulatory thing. So is your research data falling under the HIPAA regulation, for example? Or have you set up a structure in a different way? Large academic institutions can become a hybrid entity, as it's called. And so this can put the data in light of a different purpose for research only. So, for example, perhaps the institutional review board or the board that approves research use of data has said, you as a researcher can have certain types of data. And then once that data is given over to the researcher, it could fall under a completely different regulation. So another reason why it's important. But that doesn't mean, to be very clear, that the security standards are different. Because of those regulations, you're still probably going to have other state law issues that you have to deal with, even if you take HIPAA off the table. And so that's another reason why it's really important to partner with security, because you still have to secure the data the same way no matter what, because it's, patient data, or it's very sensitive, confidential type data that people, consumers, patients expect you to keep at a certain level.
And likely within the consent, it states that it'll be protected in a certain way. And then just one other thing I would add to that is it's always highly beneficial if somebody, usually the privacy officer, is actually sitting in the IRB itself. And so they're seeing these protocols come through. You can have both, depending on your organization and how you're set up. But that way, when something comes through from a protocol comes through and it looks like, hey, wait, this one in particular could be potentially, problematic. Has security seen this? Yes or no? You can peel those away, and we can be watchdogs for each other to make sure that things don't just sort of fall through the cracks.
Yeah, that's good. That's what I was talking about, being able to have a seat at the table where the other is not there, so that you can speak for that person.
Other questions?
Can your privacy officer and security officer be the same person?
Did you ask, can the privacy and security officer be the same person?
Yeah.
Yes.
Yes.
Yeah, it most certainly can.
In healthcare, you just have to designate.
Okay. And one other point, I think you mentioned on your contracting, can you build into their notification with your third parties around breach?
Yep.
And the importance of that. If you're giving them your data, you need to ensure that they notify you in the right time.
Yes, so for sure, yes. I think it's important to notify or to build into that language in the contract what is the number of days in which they have to notify you. So where I'm at, we say that they have to notify me as the privacy officer within 5 days. It's a really tight time frame because of all the reasons we already understand. I mean, we have our own obligations to take a look at things. And so I want to have the most amount of time that I can to try to figure things out. Other things are, yes, if it is an actual breach, and usually I'll have something in the contract that says, I'll make the determination of whether it's a regulatory breach or not. You'll tell me about the incident, and then I'll decide whether it's breach-worthy or not. And then moving that along, who's going to actually make the notification? So is the letter going to come from the outside entity? Is it going to come from my office? You know, are we going to negotiate that together? Or, you know, what does that look like? And then, you know, usually the things that I get the most pushback on are the secondary use of data and the liability amount, for sure. I mean, so of course I want unlimited liability, and nobody wants to give me that.
Other questions? Okay, thank you very much.
Thank you.